Okay, and it is 9:30, and out of respect for everybody's time, I want to thank you for being here. And then first, we want to start off the class by introducing our class sponsor, and it's Camille Johnson, and she's with OneGuard Home Warranty. So we're going to give her 2 minutes for and have her introduce herself and let you know what she does best.
Thanks so much, Melissa.
You're welcome.
Good morning, everyone. Like Melissa said, my name is Camille Johnson with OneGuard Home Warranties. And for those of you who aren't familiar with our plans, I like to tell people when they ask what makes you different than all the other home warranty companies, because we have so many things that make us different and make us unique. And one of those things are the services we offer. So in addition to all of the warranted items, the HVAC, the plumbing, the electrical, the appliances, OneGuard also covers things like AC and heating system tune-ups. We have rekey service and garage remote reprogramming. We offer carpet cleaning, window cleaning. We have termite treatment, pool maintenance. We'll hang light fixtures, ceiling fans. We mount TVs. We do grout cleaning. We offer dryer vent cleaning. The number of services we have continues to grow year after year. And it's actually from a panel of realtors that we have created this list that every year we find out what else do we need to offer our clients. So we have found our renewal rates have gone up significantly because now homeowners realize, okay, even if I didn't have a mechanical failure, I have the option to use all these services at a discounted rate. And I find that really valuable. So it's just one more thing to give to your clients. Once you help us get them set up the first year, it's our turn then to keep them really happy and renew them. That's our goal, keep long-term customers. But I'll follow up with each of you with our brochure, my contact information. I would love to be a resource to you for home warranty. So please feel free to reach out. We can talk on the phone. We can set up a Zoom meeting. But I'd love to tell you more about what we have to offer. So thank you and have a great class.
Thank you, Camille, so much for being here. We really appreciate our sponsors. All right, Patrick, it's all you.
All right, well, thank you, Camille and Melissa for that. So for those of you who don't know me, my name is Patrick McQueen. I'm gonna pop up my screen here just because I've got a couple of points to discuss today. I'm a real estate attorney here in Arizona. I've been doing this 16 years so far. We handle all sorts of real estate transactional matters and real estate litigation, both on the commercial and on the residential side. The topic that we're going to discuss today is sort of near and dear to my heart. We set up quite a lot of limited liability companies. We review limited liability company documents all the time for clients, developers, those getting funding through loans, those purchasing properties through their LLC or with their LLC, and those involved in some asset protection. So most business owners or most people know that LLCs are good for asset protection. And, you know, if there's a slip and fall at one of your, apartment buildings, then you're going to be in pretty good shape if you have an LLC. Let me pull up I need to pull up a different screen here. And so most folks actually know fairly well about the importance of LLCs. Can everybody see this screen? Yeah, good. Okay. Let me just change it a little bit. Let's see. Okay, so most folks know the general importance of having an LLC to protect their real estate assets or their other types of businesses, but most people don't really know why. And so we're going to take a little bit of a dive into some of that stuff very briefly today. I have a memo about this. There was an article literally this morning published about the importance of or the significance of the new Limited Liability Company Act here in Arizona. And so it doesn't look like I can't tell if my slides are sharing or not. Let's see.
They're not sharing.
They're not sharing. Okay, perfect. How about now?
Yes.
Perfect. Awesome. Thank you. Okay. So in 2018, the Arizona legislature came out with the new Arizona Limited Liability Company Act. And the implementation of the new act was was done in 2 phases. The first phase is already done. So the first phase involved new LLCs. So any new LLC formed after September 1st, 2019 must address the new act. And we're going to talk about the 5 key things of the new act and what that might do to your limited liability company. Existing LLCs, those that have been in existence already, those change tomorrow. Okay, so the second phase actually goes into effect tomorrow, September 1st, 2020. And for the second phase, for those of you who already have an LLC or who have had an existing LLC that hasn't sort of amended their operating agreement or made some internal changes, you're going to be automatically opted in to a lot of these changes unless you specifically opt out. So if you don't address certain changes, you're going to be automatically opted in, and these changes are going to be thrust upon you. So most of these changes that we're going to discuss are default provisions that will go into effect for your limited liability company unless you do something specific to take yourself out of having them automatically apply. And the goal in creating the new LLC Act was to sort of modernize Arizona business practice. There had been no real changes to our limited liability company. There had been no significant changes to our limited liability laws since 1992. And so the legislature took this opportunity to try to get Arizona a little bit more on point with some of the other pro-business states like New York and Delaware. So the 5 biggest changes, the first one is sort of easy to address. It's the place of business in Arizona. It's ARS 29-3201 and 29-3102. Previously, okay, this changes a little bit. Previously, you had to have what's called a place of business in Arizona, okay? Now, all you have to have is a principal address, and that principal address doesn't even have to be within the state of Arizona, okay? So you're no longer required to even have an Arizona address to form an Arizona limited liability company. So that's a pretty significant change. That's a pro-business change, according to the legislature and their minutes. Okay, second big issue. So first is place of business in Arizona. You no longer have to have a physical place of business. You don't have to have that anymore. You can have a principal place of business, and it doesn't have to be in Arizona. So keep that in mind. So second issue is joint tenancy and community property with right of survivorship. So in the real estate context, joint tenancies and community property with right of survivorship has always been something we include in deeds if you want your property, your real property, to go to a survivor. Okay. Now that is expressly permitted in the new Limited Liability Company Act. So previously, if you wanted a survivor, or previously, if you wanted your interest to go to somebody, there was a potential that it had to be probated. Your interest potentially had to be probated to go to another person, or you had to come up with this complicated buy-sell arrangement. Now you don't have to do that. Now, if you want your survivor to automatically have your membership interest, you can expressly put that in your operating agreement. Okay, so we're getting things are a little bit easier now with these 2 changes, with the address change, with the joint tenancy and community right of survivorship, or community property with right of survivorship. So 2 good things so far. Now I'll get into some not so good things or not so easy things. The third thing is manager confusion or manager confirmation. If you want to have a manager run your LLC, you must address the manager in your operating agreement, okay? And you have to be explicit about what your manager is able to do, the management authority. Okay, previously you could just name somebody, hey, so-and-so is our manager, and she has all of the duties and abilities that a typical manager in a typical real estate owned company or company has. Okay, so you can be very general, very vague. Well, now, under the new act, you must specifically address the manager's role in the operating agreement, okay? So if you don't, the manager-related duties and actions may not be valid. So for example, if some manager signs a deed, which they've typically always done, maybe in your company, if they've typically always signed loan documents, as they've always done with your company, and that was okay, well, now title companies may be looking for specific authority in that operating agreement. If the manager signed loan documents for an LLC, The lender may say, hold on a second, this manager does not have the authority. We're going to slow this thing down a little bit until such time as either the manager is given the authority or the appropriate person signs those loan documents. So transactions could be slowed if you don't fix that provision. So far we've addressed the address, which is okay, joint tenancy, which is okay. Now we're getting into some stuff that may not be so great. Manager, again, we got to clean up exactly what the manager can do. Otherwise, there may be no authority for certain manager tasks and things that they've done in the past. Okay, so we got to clean that stuff up. Now, ARS, I'm going to read this one to you. ARS 29-3404A. Okay, that portion of the statute says any distribution made by an LLC before dissolution and winding up must be in equal shares. Okay, well, what if I own 75%? And you own 25%, and we're just the only two managers, and we've always treated it that way. Well, upon dissolution, upon dissolution and winding up, we've sold the real estate, we're now winding up, we're dissolving, it's an equal distribution. Even though we'd always treated it one way, it's now an equal distribution, which may not be fair to me because I had always owned more of an interest, okay? So upon dissolution, it's now potentially that equal distribution. And so most people are not okay with this provision. And so most people have been deleting this provision. Okay. Remember that's one that you're opted into. So it's a pretty potentially disastrous situation. So that's why most people have been deleting that one. Now we're starting to see a pattern here. We talked about the address. That was probably a good thing. We talked about joint tenancy clarification. That's a good thing. Now there's some manager confusion. Now there's a distribution issue. And now I'm going to talk about the fifth thing, which is ARS 29-3409. Okay, this is a very large provision with some significant and large impact. Okay, what they're getting at in ARS 29-3409, and I don't have the time to review it. It's a fairly long portion of the new act. What they're getting at is the potential, or is fiduciary obligations among members. Okay. Never in the history of Arizona LLC law have we had obligations to other members. There's specific case law that basically says it doesn't exist. There's Arizona Court of Appeals decisions that say members don't necessarily owe duties to other members. Well, now it exists under the statute. Okay, so members owe fiduciary duties to each other. Remember what a fiduciary duty is. Okay, a fiduciary duty is the highest, quote, the highest standard of care. It's like what an attorney owes to their client, what a real estate licensee owes to their client. So now I may have a duty of loyalty to other members. I may have an obligation of good faith and fair dealing to other members that I might not even know. Okay, so let's think about that situation. Somebody comes in from out of state, somebody comes in from somewhere else, we're gathering members here. I may owe certain members, other members that I don't even know, that I've never even met, certain fiduciary duties. Ooh, I'm not sure if I like that. Okay, so if I owe those folks a fiduciary obligation, well, can I open up a competing business? I own a law firm with another lawyer. What if I wanted to go and consider opening up another business somewhere else? Do I have to show him or tell him what I'm doing? Is there some sort of rule against that now, or just do I have an obligation to do that now? Can I purchase other real estate? If it's a real estate LLC, can I purchase other real estate without consulting with the other members? Do I have to offer other deals to members in the LLC or to the LLC itself? What about a joint venture between a couple of LLCs, one who runs a flipping company, one who is a contracting company? Do those two have an obligation to show each other other deals? How is that fiduciary obligation going to be satisfied? We just don't know. And that's sort of the troubling part of the new act is that it may be creating more liability than what we previously had. We might not, and the other part of that is we might not be able to amend away that fiduciary obligation. So we try to limit the exposure for that fiduciary obligation if you don't want it. But there may not be a way to totally get out of having a fiduciary obligation to other members. Okay, these laws go into effect tomorrow. All right, and so what most folks have been doing, they'll do it in what's called an amended and restated operating agreement, where they will just address the specific issues that apply to them, or they'll do a simple 1 or 2 page amendment that says, we like this, we don't like this, we want this, this is how we're going to, you know, agree to on these certain things. So it's a fairly simple fix if you want to make those changes. Now there's a lot of other changes. These are the top 5 that I thought were the most concerning for a lot of those in the real estate industry. There are new record keeping obligations. There are new voting rights. So there's a married couples may get 2 votes. There's new calculations for what is considered a majority in interest. And so there's quite a lot of new changes. And so again, a lot of these things are going to be thrust upon people. People aren't even going to know about it. And hopefully now you guys know a little bit more about it. It looks like there's a couple of questions in the chat that I'm happy to address if I can. Here's my contact information, by the way. I'm happy to send you a memo. Our firm did a memo that sort of compared before and after. And you're more than welcome to have that stuff and have a memo. I can give you a sample amendment so you can see how fairly simple it is to amend this stuff. If you need any of those materials, just shoot me an email when we're done today, and you're more than welcome to have that. Same thing, if you have any questions, just shoot me an email. Most of these are fairly simple changes, but there's my contact information if you need it. Let me just see. So somebody said, are we supposed to see something? I think we got that taken care of. If you used a statutory agent previously to provide a physical address, is that, yes, you still have to have a stat agent who provides a physical address. Yeah, because that's for service of process. Can you amend via minutes rather than the operating agreement? That's another good way to do it. I would say yes. I haven't seen a lot of people doing it that way. But if you put in your meeting minutes, I would prefer that you have an operating agreement that gets amended. But I think you could probably amend by the minutes so long as your original operating agreement doesn't prohibit that. That's a good question from Sharon there for sure. Don't know if there's any other questions. So what we're also seeing are new authority documents being drafted. So we'll see consents to member or manager actions, consents to various things that people are putting into place so that they don't get burned at the last minute or are scrambling around to change things at the last minute. Another question that comes up quite frequently is, well, what about if I just own an LLC by myself? It's a single member LLC. Do I really need to worry about this stuff? We always recommend that even if you're a single member LLC, you have an operating agreement. At some point, you may need to show that operating agreement to a lender, to a title company, to somebody. So that's one reason. Another reason, the more sort of corporate documents you have, the better you're going to be if somebody tries to what's called pierce the corporate veil. And if you ever wanted to bring on additional members, having that operating agreement is a good idea. Now, with the single member LLC, there's not a lot of changes that people really need to make or really need to concern themselves with, because you can frankly always make those changes. So that's one of the questions that comes up quite a bit as well. So if anybody needs any of that stuff that I mentioned, there was an article published today in the Phoenix Business Journal about this stuff coming. And I don't think a lot of people have been prepared for it. Even though it's been 2 years in the making, we kind of had a little bit of an interruption for the last 8 months. So if anybody needs any form documents, feel free to give me a shout and let me know. Melissa, that's all I have.
Okay, that's perfect. Thanks for answering all the questions, and thanks for your time, Patrick.
Yeah, sure, guys. Have a good rest of your week, everybody.
All right, bye, you guys. Happy Monday.
All right. Bye now.